Hello and welcome everyone. Thanks so much for taking the time to join us today for our second seminar this academic term. My name is Nora Lidjan and I'm Director of the Information Law and Policy Centre, one of the academic centres based at the Institute of Advanced Legal Studies within the University of London. I expect that some of you already received notifications and updates about our events and the activities of the centre, but if not, please sign up to receive our monthly newsletter or follow us on Twitter. Now, it is my very great pleasure to chair and introduce our fantastic panel for today's seminar, focusing on the regulation of international data transfers. Our key speaker is Dr. Damien Clifford. Damien is a postdoctoral research fellow at the Australian National University, ANU, College of Law, and he joins us today from Canberra. He is also a research fellow at the ANU Humanising Machine Intelligence Grand Challenge project, and I'm delighted to say an associate research fellow here at the Information Law and Policy Centre. Previously, he was a visiting lecturer at the Dixon Poon School of Law, King's College London, a lecturer in law and honorary fellow at the University of Melbourne, and a sessional lecturer at Swinburne University of Technology. His research focuses predominantly on data protection, privacy, and the regulation of technology, and has been published in various international journals. Damien's work has also been cited by the Court of Justice of the European Union in the Advocate General's opinion in the Planet 49 case. Our discussant today, who on my screen is just below me, is Dr. Christopher Kooner. Christopher is a professor of law and co-director of the Brussels Privacy Hub, a research centre at the Vrije University Brussels, and joins us today from Brussels. He is also an associate of the Centre for European Legal Studies at the University of Cambridge and a visiting professor at Maastricht University. He is editor-in-chief of the law journal International Data Privacy Law and one of the principal editors of the commentary on the GDPR published by Oxford University Press in 2020. He is also senior privacy counsel in the Brussels office of Wilson Sonsini, Goodrick and Rosati. Welcome to you both. In terms of the format for this seminar, Damien will present his working paper. Christopher will then briefly respond with his thoughts and analysis. We will then open up the discussion to the digital floor, shall we call it, or more accurately, the Zoom webinar chat box, which is right below your screens for the Q&A session. Any discussion in the Q&A session today operates under the Chatham House rules. This means that you are very free to cite any information or opinions shared in the Q&A part of the seminar, but neither the identity or the affiliation of any of the speakers should be attributed. The Q&A section of today's seminar will not be recorded, so this is to encourage as much candid and open discussion and debate as possible. But Damien's presentation and the panel discussion will be recorded and made available on our website afterwards. So now I'd like to thank our speakers and you again for joining us today, and we'll invite Damien to begin this seminar on international data transfers between EU and non-EU states, trade negotiations and the reform of the Australian Privacy Act. Whenever you're ready, Damien. Thank you.
Thanks, Nora. I'll just share my slides now. Okay, so you should have them, hopefully. I'll just see if they work.
That's perfect. Thanks, Damien.
Okay. Yeah, thanks very much, Nora. I suppose I should acknowledge at the beginning that the title is going to focus quite a lot on the reform of the Australian Privacy Act, because I think that's going to be quite an interesting point of discussion when it comes to the legitimacy of, I suppose, data transfers going forward. But also, I'm going to set that within the ongoing trade negotiations. And I suppose, given the fact that it includes the negotiations around digital services, which of course would involve data, and then I'm kind of interested then in the potential disparities between the frameworks and what Australia's chance of an adequacy agreement would actually be. So, starting out from this, I suppose the kind of catalyst or inspiration from the paper, are the three of them really are listed. So, it's from the Schrems 1 and Schrems 2 decision, and trying to find essentially whether there is essentially equivalent protections afforded. Then, as I mentioned, the trade negotiations between the jurisdictions and the fact that it includes trade and services, which inherently then involves the international data flows that are associated with that. And then the Australian Competition and Consumer Commission, they released a digital platforms inquiry report, which speaks a lot about the potential changes to the Privacy Act, and then there's been government responses. And part of that is the potential seeking of an adequacy agreement. Now, at the outset, I suppose I want to acknowledge that in my own view, and putting it quite bluntly, there isn't much of a prayer of an adequacy agreement. So I want to kind of lay my cards on the table a little bit from the outset. And more, I suppose my aim then is to kind of wonder at what point this is going to be raised in the trade negotiations. You know, the Privacy Act was introduced in Australia in 1988, but there's a complex system given the fact that it's a federated system here. So there are different pieces of legislation that have an impact on this at the state level as well, but it does provide, I suppose, the key Commonwealth piece of legislation. Okay, so just a little bit of background on the trade negotiations themselves. So they were launched in June 2018, and I suppose just in terms of the economic significance of it, these are details coming from DFAT, the Department of Foreign Affairs and Trade in Australia. So the EU was Australia's second largest trading partner, so there are, I suppose, key benefits to trade, and there are the key benefits, I suppose, to looking at a free trade agreement between the jurisdictions. Now, I've included a quote there, but I'm not going to spend too much time on it. I'm happy to share the slides with anyone, but I think I'll move on rather than reading from the slide. But I suppose what I kind of want to get at, and what I was interested in, was actually what the EU starting position was in relation to data protection and privacy in approaching these trade negotiations. So when I looked in at what the Commission documents say, I mean, it's not very surprising from an EU perspective, but it does kind of give a lens through which you can kind of consider some of the potential disparities between the protections that are afforded in the GDPR versus those that are afforded in the Privacy Act. So the first one is each party recognises the protection of personal data and privacy as a fundamental right. From the outset, it can be acknowledged that they don't. Australia doesn't have a right to privacy, let alone data protection. So that's already problematic to begin with. And the other one that I have in bold is also interesting in that they define personal data. So this Commission document as basically how it is defined in the GDPR. But I'm going to come back to that in a little bit more detail later on, and why that's potentially problematic with respect to a federal court decision here in Australia. So before kind of getting into any potential disparities, I should acknowledge that both frameworks have a lot of similarities, and that they're both principle-based instruments. They have very similar historical underpinnings in terms of the OECD guidelines, etc. So there are a lot of similarities between them, and I think an EU data protection and privacy expert looking at the Privacy Act would see a lot of similarities across them. So, I mean, obviously there's a lot of degree of uncertainty in terms of how the balance is to be struck when you're actually implementing these principles. And at a point that I'll return to later is what significance the lack of a right to privacy, let alone a right to data protection, means for the interpretation of these principles in terms of practical implementation and enforcement here in Australia. So I mentioned that the Digital Platforms Inquiry and the final report was issued last year. But it's important to note, and as I mentioned earlier, the Privacy Act has been was adopted in Australia in 1988. So they've had privacy regulation here I mean, even before, I suppose, the old 1995 directive. So there is quite a history of, I suppose, what they would call data privacy protections in this jurisdiction. However, it's already been analysed to a large extent, I suppose, even with the prior European safeguards in the old directive, that the Privacy Act would just simply not get an adequacy agreement even then, let alone the GDPR. Now, as I mentioned, in its platforms inquiry, the ACCC, in its recommendation 17, recommended the broader reform of Australian privacy law. So point 6 of that refers specifically to overseas data flows and the adequacy agreement. And basically the quotation in the bullet point simply refers to the ACCC suggestion that it should be considered whether adequacy could be sought from the European Commission to allow the free flow of data between the jurisdictions. And it also recommends changes that are largely inspired by the GDPR. And I'm going to come and I'm going to address these in particular so you can see where the policy momentum is in this jurisdiction and how inspired it is actually by the GDPR. So now to begin with, I thought I'd list some very notable ones that have always been kind of trotted out, I suppose, and then I'm going to get into some more detail on 2 of them. So the last 2 on the list that I've just underlined. But first of all, I suppose just to kind of go through the others roughly, because within the broader reforms of the Privacy Act and Recommendation 17, the ACCC suggests that they should be considered within that in order to seek adequacy. Now, I've already mentioned the first one in terms of the lack of a right to privacy, let alone a distinct right to data protection. The other ones worthy of mention are that there's a small business exemption, and as you can imagine, given that small businesses effectively account for the majority of businesses in any jurisdiction, that is a massive exemption. Now, there are also exceptions to that exemption, but it still has, even that alone, I think, would effectively mean that adequacy could never be achieved. There's also an employee records exemption, and there has been recent case law on that, which seems to narrow it to a certain extent, but at the same time, it would definitely indicate that there is a narrower approach. And then the other one that I want to mention before going into detail on the others is that individuals cannot bring claims on their own for damages. So they can go for an injunction, but there's no right of action for claim for damages that, as an individual, you can go before the court. So as I said, I want to kind of look into the other 2 in more detail with reference to, I suppose what's currently on the books here in the Privacy Act, and also then with reference to the ACCC reforms. In the first one, I'm also going to mention the potential changes or the suggested changes in the recommendations around sensitive personal data or sensitive personal information, as it was referred to in the Privacy Act here, and the protection of that, in particular in relation to inferences. So just to kind of lay out the definitions, and the reason I want to kind of do this, I realize that there's a lot of text on the screen and it's not the easiest thing to kind of go through. I realize that it's still relatively early in the morning for you, but I just want to show really, I suppose, the broad scale similarity between the 2 definitions as effectively, the threshold for application of the respective piece of legislation. So as I assume a lot of you are very, very familiar with the GDPR, so the definition basically saying any information relating to an identified or an identifiable natural person, that kind of, you can see broad similarities within the Privacy Act definition, which is information or an opinion about an identified or an identifiable or an individual who's reasonably identifiable. Now, what's interesting, I suppose, is that although both definitions are extremely similar, the Australian definition has been interpreted in a very narrow sense, essentially circling around the word about as opposed to relating to. full federal court in the Privacy Commissioner and Telstra in that decision effectively said that there has to be a far closer link than is required under EU law to the individual. So the information has to be about them. And effectively, that's where that interpretation springs from. Now, I just to kind of highlight that difference, I suppose, and I think a lot of you are already familiar, but within the NOAC decision, we know that the relating to criterions effectively have three different elements, or has three different elements within it. So the content, purpose, or effect. So the content, I think here you could probably broadly align within, you could say it's broadly similar to about, but the other two elements in the relating to criterion seem to be missing from the Australian, or at least the full federal court's interpretation of what is personal information under the Privacy Act. Now that's a significant difference in and upon itself. What's also interesting is, I suppose, just the court's, the Information Commissioner, I suppose, of the general interpretation within this jurisdiction of what amounts to identifiable information, which also seems to be far narrower. Now, any of you who are familiar with, the Australian policy over the last few years will know about the release of public sector information, which basically was found to be identifiable, or it was re-identified basically. So there seems to be a bit of an issue around here also in terms of the identifiability criterion and what fits it and what doesn't. And then I suppose a kind of now out of date interpretation or view of how anonymization can actually function. So that's the essential difference between the two definitions as provided for within, just a comparison between the two notions, personal data in Europe and personal information under the Privacy Act here in Australia. Now, that has major potential impacts. I'm taking this as a graph that is in a paper that I've written with Megan Richardson at Uni Melbourne and Karen Clark and Rochelle Basua. So it just kind of like spells out, okay, at what point does the definition of personal data engage? Now, this one is referring, I suppose, to there's a comparison between them. And again, I'm happy to, share the slides afterwards. But basically, it draws into question, I suppose, whether information such as device-related information could ever be considered about an individual, which has major implications when you think of kind of IoT devices, etc. But also, I suppose, other tracking software that are used regularly, I suppose, when it comes to programmatic advertising, etc. So there are major practical implications and uncertainties which actually stem out of that difference in the definitions. And what's interesting, I suppose, from a general or broader Australian policy perspective is that, the legislator is well aware of this. So when it comes to something like the COVID related legislation to allow for the use of a COVID app in Australia, the legislator was at pains to include such device related information within the category of data that was protected under the Act. So there is, I suppose, broad scale awareness of the issues that stem from a narrower definition. Now, moving on then, just to kind of introduce generally what the ACCC is recommending in their digital platforms report. So I'll kind of come back to a couple of these later on, but you can see I put in the government responses alongside what each of the recommendations are. And you'll notice, I suppose, some of them relate to issues that I identified earlier within that might prevent a potential adequacy agreement between the jurisdictions, or an adequacy agreement finding from the European Commission. So you can see, I suppose, particularly in relation to this one, in recommendation 16A, you can see that the government responds to an update of the definition of personal information, that they do support this in principle, subject to there's going to be some consultation, etc. Now, what's interesting about this is that basically the definition that the ACCC plucked, they basically plucked it from the GDPR. It is verbatim what is defined as personal data in the regulation. So, I mean, that's interesting in itself, given, but probably not surprising in many respects, but it is kind of noteworthy. What is also interesting is that in those kind of broader reforms, which in recommendation 17, where the government has said that they support a review of the existing Privacy Act and the need for a potential change, they've also kind of got onto this kind of identifiability anonymization issue and what to do about this, de-identified pseudonymous data. Now, as I think many of you listening will know, pseudonymous data is, of course, personal data as defined very clearly within the definitions provided in Article 4 of the regulation. So it is interesting that the ACCC is suggesting that type of approach as well. But what is, I think, kind of slightly more interesting from my perspective is that is actually contained in a different recommendation to the recommendation that then the recommendation to modify the definition. So there's also kind of an issue around how that definition would be interpreted vis-a-vis the identifiability element within it. Another one that I wanted to discuss, I suppose, and I already flagged this, was the inferred information and what it might mean in terms of the potential with intensive data processing and the blurring of the boundaries between the personal information and sensitive personal information categories. So very similar to the GDPR, the Privacy Act lays out currently it lays out a very similar set of sensitive personal data categories. So that is, that has been there for some time, and it kind of broadly conforms to what you would expect, I suppose, even stemming from the historical roots within the OECD guidelines, etc. But what's interesting then, I suppose, is that they're looking at how to deal with these inferences. And again, I suppose the fact that this is a separate issue within the broader reform suggested of the Privacy Act. Whereas I suppose it's probably, although I mean it's an issue for interpretation within the GDPR and how to deal with inferences, but inferred data, I suppose, through a fairly conventional understanding, if it is inferences related to health, would certainly already fit within the sensitive data category. Okay, moving on then to the second of the two elements that I want to look at, and consent and control, legitimate grounds of processing, and the application of responsibility. Now, as you all know already, I think the GDPR has its 6 grounds for processing as laid out. And if we're kind of just limiting this to, I suppose, commercial data processing, we've got 3 in particular that we look at, and then we have the data subject rights on top of that, which effectively balance out the framework, providing some, semblance of control for the individual data subjects. Now, like when the GDPR was adopted, and again, I think I'm preaching to the choir here a little bit, we do know, I suppose, that there was a lot of kerfuffle around what that meant for consent, and I think there's still quite a lot of uncertainty in terms of its enforcement and implementation, and the seeking of consent, again, for existing data processing operations. What's interesting, I suppose, about the Privacy Act is currently there's an extremely limited role for consent as a necessary condition for processing. It's very limited. It is only necessary, as laid out on the screen on the slide, in 5 particular contexts. So the collection of sensitive information, so the collection of personal information from someone other than the individual concerned, the use or disclosure of personal information for a secondary purpose, the use or disclosure of personal information or indeed sensitive personal information for direct marketing purposes, and finally the transfer of personal information to an overseas recipient. What's even more, I suppose, alarming from a GDPR adequacy perspective is that consent under the Privacy Act is defined extremely broadly as both express and implied consent. And, you know, I mean, implied, I think, interpreted extremely loosely. So, you know, in terms of use of a particular website or whatever. So it is seeing, I suppose, something more akin to kind of formal consent as opposed to providing any kind of a substance behind it. Now, this, of course, creates a massive disparity between what is provided in the GDPR and what is provided in the Privacy Act. Now, back to the ACCC recommendations, and there are two here that are worth looking at. I'm going to kind of go through in a little bit of detail. So the first one is 16B, which refers to the need to strengthen notification requirements. And of course, transparency is extremely important for the validity of consent. And then we have 16C, which is the strengthening of the consent requirements and pro-consumer defaults. With consent, I've laid this one out in a little bit more detail compared to the personal information update. So what effectively the ACCC is suggesting is a consent-based approach. They're basically saying that consent will be required, you need to obtain consent wherever a consumer's personal information is collected, used, or disclosed by an APP entity. So effectively the controller, because it's all classified within the APP entity, unless the personal information is necessary for the performance of a contract, which the consumer is party or is required under law or is otherwise necessary for an overriding public interest reason. Now, again, there is broad similarity with what we have in the GDPR in terms of the 6 conditions for lawful processing. However, it is kind of, you know, a major difference in that here there are exceptions to what is a consent default, whereas in the GDPR, all 6 conditions stand on equal footing and have, you know, at least through a purist interpretation of the GDPR, a defined and delineated role and pointing at their significance individually. What's also interesting is the fact that the ACCC expressly omitted and suggested that it shouldn't be included. So the legitimate interest, even if it was supposed to be an exemption, but they expressly omitted including anything akin to what we have in Article 6.1f of the GDPR, a legitimate interest condition for processing. Now, in a paper that I'm writing at the moment with Lorenzo Della Corte, we're looking really at why, you know, that's problematic even from a functional perspective, because what you'll end up doing is just expanding one of the, you know, contract or consent to suit existing data practices. But you can kind of see, I suppose, there is a certain philosophy coming out, very consumer protection focused recommendations, I suppose, you know, and that's hardly surprising given the fact that we're talking about the ACCC, given that their mandate is competition and consumer law issues. Now, again, similar to the personal information update, you could, you know, what is actually suggested in terms of the modifications around consent substantively within what it will be included in its definition is almost, it's verbatim again from the GDPR. So we have a clear affirmative act that is freely given, specific, unambiguous and informed. And, you know, you can see very much the same style of thinking that you would have currently legislated within Article 7 of the GDPR. Okay. So I'm probably going to kind of speed up a little bit because I'm seeing that I'm already, it's already half us. So the other part of this, I suppose, is the strengthening of notification requirements. And I suppose, given the fact that they're suggesting the adoption of a consent-based approach, it's hardly surprising that they're not going to give some weighting to the importance of providing some degree, you know, notice and transparency, as is also evident in the GDPR, the significance of the transparency principle. And you can see, again, many of the same ideas in terms of, concise, transparent, intelligible, and easily accessible, written in clear and plain language. Really very similar language that is contained in the GDPR, in particular, say, Recital 42, which makes a cross-reference to the Unfair Terms Directive. So there's, again, large inspiration taken from what is currently in Europe. Now, I suppose I've already answered this question to a certain extent. I mean, there are clear difficulties with having a solely consent-based approach and not also legislating for the potential of this kind of catch-all balancing condition to kind of, take out certain things that don't belong in either contract or consent as conditions for lawful processing. And this is particularly evident given the fact that, in addition to what they're defining as consent, they have a very similar interpretation to what is contained in the GDPR of what contract is supposed to mean, what public interest is supposed to mean, etc. So there are potentially problems with what they're suggesting, also given the fact that they're trying to adopt this within a Privacy Act that has, it's an omnibus regime, and it's not singled out for the application to digital platforms in particular. Now this is my last slide. So I just kind of, I'm just going to kind of give some degree of a conclusion from what I've said in relation to, the ACCC recommendations, in that, like, I think that there are major problems, even if they were all adopted. One more slide after this, sorry. But, that there are significant problems in terms of implementation and how they would actually compare, practically speaking, to what we have in the GDPR. But I want to acknowledge, and maybe Chris will take up on this a little bit, but that, adequacy is there's two sides of the coin, and it'd be kind of remiss of me if I didn't mention some of the public law powers that exist on the law enforcement side and national security side, which obviously were significant in the court's decision in Schrems 2 decision. So they're just pointing out two of these. So you have the Interception and Access Act, and you have TOLA, the Telecommunications Act, that was updated by the Telecommunications Legislation, other legislation amendment, Assistance and Access Act. So I just want to maybe just highlight two parts, just a couple of things from these. The first one, I suppose, given the fact that it was updated in 2015 by the Data Retention Act, there are broad scale powers here for law enforcement. There's a requirement to retain data for 2 years. There's no requirement to delete that data. When you're looking at TOLA, there's no there's no judicial oversight, that would be there within the IPA in the UK, and I'm sure Nora would have something to say about that. Now, so there are broad scale problems on the other side of the coin as well. So it really paints a fairly dismal picture in terms of the possibility of getting an adequacy agreement with the EU. So this leads me, I suppose, to a couple of questions that I'm kind of toying with, and I think it, effectively will frame this paper whenever I actually get a chance to finish it and write it out properly. But the first one kind of relates to, well, what is the practical significance of the fact that there isn't a Charter of Rights, a Bill of Rights here that includes, a right to privacy, let alone a right to data protection. I'm kind of wondering, very practically speaking, if the GDPR was adopted here in the morning, what would actually happen? It would be, I've no doubt that it would kind of be interpreted in very different ways to what we have in Europe, which would lead to disparity in any case. So, like, fundamentally, it's very hard to get away from the difficulties around not having a Charter of Rights. The second one, that I want to highlight kind of relates to the last slide. So, basically, given Australia's approach to the public law aspects of this, there doesn't seem to be any chance of getting adequacy, even if the GDPR was adopted here in the morning. And that, I think, it broadly relates again to the fact that there isn't a Bill of Rights to do this kind of proportionality necessity kind of test through a judicial review system in order to ensure that the adequate balance was actually struck by the legislator. And that kind of leads me to the core question that I've been kind of pondering a little bit, in that, you know, although the EU legal order allocates privacy-related issues to its adequacy rulings and not to the free trade agreements, I'm wondering, well, is that really, you know, isn't this a bit of a problem, really? Because, you know, at what point in the discussions are they going to kind of turn around and say, we actually have a major issue here in terms of trying to ensure that there is, we can actually facilitate the free flow of data across in order to allow for free, you know, for the trade in digital services. So I'll leave it at that, and I look forward to your questions and also to Chris's intervention. Thank you.
Thanks so much, Damien, for that really rich and very comprehensive overview of the privacy law framework in Australia. I don't want to say too much before Chris's contributions, but only to say that it's not looking good, is it? To put it quite bluntly, for an adequacy agreement between the EU and Australia. And I think you detailed very well how so many problems arise on both sides of those coins, both within the private sector in terms of the disparities between the GDPR secondary legislation, particularly regarding consent and the definition of personal data, to name just a few. And also, I think with regards to the public sector requirements, I think the Schrems judgment back, the first Schrems judgment, back in 2015, has really made, you know, that very broad and, you know, initially, you know, on the first blush concept of essentially equivalent, you know, as actually being, you know, quite misleading. You know, there are some very far-reaching and hugely prescriptive requirements that the EU legal order now appears to be looking for from other non-EU states if adequacy is going to be a possibility. But before I say any more, I'm going to turn over to Chris, who's very much a leading expert in data transfers within EU law. Chris, whenever you're ready, thank you.
Thank you very much, Nora, and thank you for inviting me. It's a pleasure to speak with all of you. I'm going to really be brief and limit myself to 10 minutes to react to what Damien said and maybe pose a couple of questions. So first of all, this has been, I think, a very interesting and a very good presentation. I knew almost zero about privacy in Australia before this presentation. I now know a lot more. So it's made me curious too to learn even more. So thank you for that, Damien. And I think what Damien has said raises several important questions. So we have had indeed in the EU these very important Court of Justice judgments in the last few years that have sort of implemented the requirements for adequacy decisions with third countries. And the GDPR has a lot of criteria, but it still leaves a lot of questions open about these decisions. And so the court's judgments have really filled in a lot of the gaps. And it has raised a very high standard for adequacy decisions, which I will talk about in a moment. So Damien has done a very good sort of forensic job of going through the proposed legislation in Australia and pointing out some specific potential problems with it. And I think this is exactly what the European Commission does in its adequacy negotiations. It really sits down with a translation or a English version of the relevant third country law and looks through them and says, wait a minute, this looks different than what's in the GDPR. So it's kind of a matching exercise. And thus, I think the points you've raised are quite valid, that these are probably things that the Commission would raise. There's also a political aspect to these adequacy decisions, and the Commission published a paper in 2017 when it said very clearly we will give priority to reaching adequacy decisions for our biggest trading partner. So this plays into it, and I I looked at the status of Australia among the EU trading partners, and it's true it is growing, but it's not massive at the moment. It's number 21, 1.0% of trade. By far the biggest three are the US, China, and the UK. And this is relevant because you can certainly see, for example, with the US, there was just huge political pressure to reach some accommodation, and that's probably why the safe harbor and the privacy shield were agreed to. Of course, they were later invalidated. So the fact that there's political pressure doesn't mean that it will be a good quality decision. But I doubt that there will be this sort of huge, massive political pressure within the EU to reach some accommodation with Australia. I don't think that the numbers are there. I'm sure that they would like to have an agreement. It would be nice to have, but it's not going to be at the top. And at the moment, of course, in Europe, we have a lot of problems with data flows. There's the issue of Brexit and what to do with the UK. The Commission is in the final stages of talking with South Korea and other countries like Brazil. So Australia is probably in the mix there, but it's not right at the top. And then in terms of the legal standards, the court has set indeed a very high standard in both the Schrems 1 and the Schrems 2 judgments. And recently, a couple of weeks ago, there were these other two judgments, Privacy International and Quadrature du Net, which didn't deal with international data flows, but they're certainly relevant to the level of protection in the EU, and therefore are also relevant to what can be demanded from third countries. And maybe the jury is still out as to exactly what they mean in practice, but there are parts of those judgments which also set a very high standard with regard to intelligence surveillance. So we have a situation now where we really are demanding quite a lot from third countries if we're going to give them this adequacy decision. And it's important to state again, this adequacy decisions, this isn't like really a treaty where it's sort of agreed with both sides. This is a unilateral act that, at least this is the way the EU sees it, that's granted, as is the case with financial services and other areas where there are adequacy decisions. So the EU has to really be convinced that there is an essentially equivalent level of data protection. And I think Damien made another very important point, that this isn't just about, will Australia sort of take the GDPR and transpose it word for word? Because the Court of Justice has said that the level of protection must be effective in practice. And so, as I think the words you used, where it has to work the same way. So this isn't just a kind of, and maybe sometimes some people in governments have the wrong impression. We'll just take the GDPR and sort of copy and paste it in, but it has to work within the legal system. So the constitutional system of the third country, also things like administrative law system, which are, within the GDPR, there's still a very big role for national member state law. For example, bringing complaints to DPAs, this is all done under national law. So we'd have to look at the administrative system in Australia. So there's a whole level beyond just what the GDPR says as to how this would actually work in practice. And I think the EU would look very strongly about that, or at that. And so I know my time is limited here, but I maybe sort of in conclusion make a couple of other points. So it seems to me Australia has a lot going for it because it's a democracy. It has the rule of law, and so at the high level, there's probably a lot that could be found to be similar with the EU system in terms of great respect for the rule of law and et cetera. But the issue is, once you start going more into the details, the Court of Justice really demands, with regard to at least certain details of the legal framework, quite a close similarity. And if you look at the Schrems 2 judgment, you'll see there's really basically three things the court requires for, at least this was, of course, the Schrems was about the US, but in that case, it sort of identified three things. Number one, protections that are essentially equivalent to those under EU law. And that will then get to the kind of the legal framework that's adopted. And then secondly, incorporating the court said, effective mechanisms that make it possible in practice to ensure compliance with this standard. So this is the second half of the equation, which is really the practical side, not just what the law says, but it has to actually work in practice. And then thirdly, the court put a particular emphasis on a few areas. So appropriate safeguards for data flows, having enforceable rights for individuals, and then effective legal remedies for individuals too. In particular, in at least a court or court-like setting. And Damien has already spoken about that. So these are all things that, at least in theory, they're not impossible to meet, but they are judged under quite a high standard. And so I think this means this is relevant not just to Australia, but to all third countries that will have these discussions with the EU, which is we've set now really quite a high bar in the EU for having adequacy decisions. And I think the implications of this are kind of unclear at the moment, because ideally, if we want the GDPR to have influence, we want a high standard, but we don't want to have an impossible standard, because if the standard's impossible, you would say as a third country, why should I even try then? So in order to give some incentive to adopt it, it has to be reachable, at least in theory. And the court now has kind of set the standard for the next few years, but we have to see how this works in practice. Will countries kind of ramp up their standards to meet the EU standard, or will they, at least some of them, say this is too difficult, I don't care, we'll just go our own way? I don't know, but these are some of the questions that are raised. So I think my 10 minutes is up, and I should turn the floor back to Nora now.
We learned a great deal about the Australian legal privacy framework, and I think the insights that you provided, Chris, were incredibly thoughtful and applicable to many other states, including the UK, in terms of future adequacy agreement talks. So thanks so much to everybody for joining us today.